everyone. So I'm here to talk about legal professional ethics. Some of you will know me. I'm an independent children's lawyer in the children and young persons team. What's the difference between acts that are ethical, legal, and illegal? We've all studied legal professional ethics at university. We're all aware that as solicitors, the Australian Solicitors Conduct Rules govern our ethical behaviour. Just being told to speak up, and that's for solicitors. For counsel, of course, you refer to the Bar Association rules. The purpose of today's presentation, though, is to remind us all about our duty to the court and to the administration of justice, and to recognise instances when that duty is clashes with our other duties and other interests. So our clients sometimes think that the primary duty of the lawyer is to secure a judgment or a decision that is favourable to the client. In Gianarelli and Wraith, Justice Brennan stated, "This is not so. The foundation of a lawyer's ethical obligation is the paramount duty owed to the court. It is the courts who enforce the rights and protect the citizen against the state, who enforce the law on behalf of the state, and who resolves disputes between citizens and between citizens and the state." In an article by Chief Justice Warren of Victoria, which was published in the Bar Association Journal in September of last year, Chief Justice Warren said, "It is the lawyers, through the duty to the court, who form the legal profession, who underpin the third arm of government, the judiciary. Without the lawyers to bring the cases before the courts, who would protect the citizen? Who would enforce the law? It is this inherent characteristic of the duty to the court that distinguishes the legal profession from all other professions and trades." Her Honour went on to note there are three things. Firstly, to become a lawyer as a law graduate, you have to present for admission, you have to take an oath or an affirmation, wherein you declare that you will conduct yourself well and honestly in the practice of the profession and as an officer of the court. In taking the oath and affirmation, the graduate is transformed from one who holds a law degree to one who is now a lawyer and subject to the duty to the court. Thirdly, she says, whether the lawyer is a corporate lawyer, a family lawyer, or a criminal lawyer, the duty to the court is the same. So what is ethics? It is about behaviour and conduct. In an address by Sir Gerard Brennan to the Queensland Bar Association in May of 1992, His Honour is quoted as saying that they are not so much learnt as they are lived. What is the meaning of ethical? The English Oxford Living Dictionary defines it as moral principles that govern a person's behaviour or the conducting of an activity. What is the meaning of legal? Same dictionary. Appointed or required by law, permitted by law. What is the meaning of illegal? Something that is illegal is against the law. Consider, therefore, just because a course of conduct is not illegal doesn't render it ethical. Now, I was roped into doing this talk because last year I had a trial, and in the course of that particular trial, the question of conflict arose, and I ended up successfully having a solicitor removed from a case, and I ended up getting an order for indemnity costs personally against the solicitor. And the following week, I got yet another order for costs against another solicitor. So here I am. Thank you, Ms. Terrence. So, as I said before, solicitors' ethical obligations set out in the Australian Solicitors Conduct Rules, and for counsel it's in the Bar Association rules. However, these rules are not exhaustive. They're not an exhaustive list of our ethical responsibilities, nor do they provide an exhaustive list of the answers to ethical issues and problems. They provide a framework, and they have to be read in conjunction with the common law and equity. In modern day practice of law, there are various competing interests that a lawyer has to be aware of and then to deal with from time to time. For example, commercial pressures of a law firm, billable time, right? Got to meet your budget. Clients' instructions and clients' expectations. Rule 8 of the Australian Solicitors Conduct Rules requires us to act lawfully, properly, and competently in our instructions. Consider that clients' expectations drive the client's instructions, but that doesn't mean that everything they request of us to do, we should do. Robustly representing your client. Yes, we're required to do that, but that doesn't mean that we ought to be the client's mouthpiece. Rule 17 of the Australian Solicitors Conduct Rules. We need to reality test our client. Complying with court directions is also something that we have to do. Not just our clients, but us as well when we're representing the clients. The challenge arises when the duty to the court and the administration of justice comes into conflict with these other interests. The duty to the court and to the administration of justice are inseparable. The duty is paramount. Rule 3 of the Australian Solicitors Conduct Rules. We have other fundamental ethical duties as well, and that's set out in Rule 4. We must act in the best interests of the client. We must be honest and courteous in all of our dealings. We must deliver legal services competently, diligently, and promptly. So consider we have to comply with directions. We have to avoid compromising our integrity and our professional independence. We have to comply with these rules and with the law. So the bottom line, the duty to the client is subordinate to the duty to the court. The duty to the court supersedes the desire to win the case in accordance with the expectation of the client. As lawyers, you are urged to be vigilant in your everyday practice as an officer of the court, and there are standards of professional conduct attached to this role. So, what is the, sorry, hang on a minute. What is the administration of justice? What does that mean? In an adversarial legal system such as ours, much depends on the exercise by the lawyer of an independent judgment in the conduct and management of the case. In Gianarelli and Wraith, the case was about the alleged negligence of counsel in the course of a trial. Chief Justice Mason held the duty to the court is paramount and must be performed even if the client gives instructions to the contrary. His Honour went on to say, rather, it is that a barrister's duty to the court epitomises the fact that the course of litigation depends on the exercise by counsel of an independent discretion or judgment in the conduct and management of a case in which he has an eye, not only to his client's success, but also to the speedy and efficient administration of justice. In selecting and limiting the number of witnesses to be called, in deciding what questions will be asked in cross-examination, what topics are to be covered in the address, what points of law will be raised, counsel is exercising an independent judgment so that the time of the court is not taken up unnecessarily notwithstanding that your client may wish to chase every rabbit down its burrow. So, in other words, part and parcel of the administration of justice involves you as lawyers working out the strategy for your client's case, presenting your client's case. That includes the drafting of material, considering what needs to go into evidence, considering what evidence you need to gather, whether you need expert evidence, what experts you need, what documents to file, and what submissions to make. If you're an ICL, sometimes you need to consider the order of the expert witnesses. You know, in the family court, there's a direction about having the expert give evidence first before the parties, but as the ICL, I would suggest that you need to exercise some discretion about, well, should I have my expert first rather than the parties first? Because what if I have to recall the expert? And if you decide that you need to have parties first before the expert, then you need to make an application to the court to change the order of things. So the decision about these matters that are being made by the lawyer, not the judge. Examples of what this clash between your primary duty and other interests may look like. First example, when you're acting for a well-resourced client, there can sometimes be a disincentive to settle the case quickly. The client may want to pursue every avenue for tactical purposes. We've all been there, where we're legal aid lawyers and there's somebody privately funded and they bring application after application. And this protracts the dispute and the legal proceedings. It's the lawyer's duty in the administration of justice to assist the court to reach a proper resolution of the dispute in a prompt and efficient manner. You've got to be cost effective, right? Example 2, when the client is insisting that a lawyer pursue a particular strategy or line of questioning in, say, cross-examination, it is the lawyer's duty to restrain the enthusiasm of the client and confine their evidence to what is legally necessary, right? We've all been there. And then sometimes you can't, and then you stand there and go, "We are instructed, Your Honour, code speak." It's your duty to reality check your client. You're not just a mouthpiece. Rule 17 of the Australian Solicitors Conduct Rule. Example 3, when you are representing party A and the other party is self-represented. As the only legal practitioner involved in the case, whilst promoting your client's case, the overarching duty to the court and the administration of justice requires the lawyer to acknowledge the vulnerability of the self-represented litigant. So what does this mean? For example, it can mean, when there's a self-represented litigant, that you explain to the litigant the process for today in a directions hearing, or explaining after the directions hearing what exactly went on in the courtroom, what orders were made, what documents they need to file, remind them when the case is next before the court, and these days remind them they need to register on the portal to get a copy of the order because it's no longer being sent to you. Another example, when the duties clash, failing to comply with the court's direction. For example, not filing your material on time. Your client may be slow in giving instructions to you, thereby affecting your preparation. Or you have left your meeting with your client for instructions to the last minute, thereby affecting the timely preparation and filing of your material. Consider that in failing to file your material on time, this may have an impact on the other party's preparation. And this, in turn, will have an impact on the readiness of the case for trial. You may have to go to trial later rather than sooner. Everyone is trapped in the delay, including the court. It's the lawyer's duty to the administration of justice to ensure that the orders are complied with, and it's your duty to ensure that you manage your client so that the directions are complied with. If you're an independent children's lawyer, it may be that you need to talk to the self-represented litigant about the limitations of their case in light of the overall evidence. and recommend that they seek independent legal advice. It may mean the ICL providing to the self-represented litigant information in trial preparation. I know some of the judges make orders that ICLs publish to the clients a copy of Section 60cc so that they know what to address when they're filing their evidence in chief. For a solicitor who holds an appointment as an independent children's lawyer, there are further specific duties imposed by the Family Law Act, and that's all set out in Section 68LA. I won't go through all of that. However, essentially, as an ICL, you must form an independent view based on the evidence that's available to you in your case of what is in the best interest of the child, and you must act in relation to the proceedings in what you consider to be in the best interest of the child. As legal aid lawyers, we're also governed by Section 74 of the Legal Aid Act. Legal aid, or a legal aid lawyer, in performing our duties under the Act, A, must observe the rules and standards of professional conduct and ethics a private lawyer is required to observe, and B, is subject to professional obligations to which a private lawyer is subject by law or custom in legal practice. So each case is different, with each set of circumstances presenting their own challenges. It is for you, the lawyer, to identify in any given case what is your duty to the court and the administration of justice. So I've handed out a fact scenario, which I'll give you a few minutes to read.
Does anybody not have a copy?
So the reality is that the question of whether there is a conflict of interest is not always cut and dried. The challenge for all of us is to recognise when there is a collision or a potential for collision between the duty to the court and the other interests and what to do about it. It's my submission that just because what we are doing is not illegal doesn't make it ethical. So this fact scenario is based on a real-life case that went to trial in the Federal Circuit Court here in Brisbane at the end of last year. And I do apologise that it's so lengthy. However, in preparing for today, I tried to edit a lot of it out, but you know, it was just too crazy and I had to include everything. So, so we'll just work through it shortly. I'll just give you a few minutes to read it. everyone just about finished? Yep, can I start? Okay, so your task is to help me identify, having regard to your duty to the court and the administration of justice and your other fundamental ethical duties, identify what areas of concern in this fact scenario do you have, if any. You may not have any, and if you don't, I'd be worried. So, somebody. Yes, John?
Well, you're acting for someone who's basically a family member in a family law matter. It clouds your judgment.
Yes.
I appreciate that a lot of people say that there's no reason you shouldn't do it, but to my mind, it's conflict of interest.
Yes, so in this particular case, Billy Ray, the solicitor for Rhaegar, Dad, right, he says that he asked the Law Society, he spoke to them and they said to him it's not advisable, but it's not illegal, and so he continued to act. And at the time that he made the inquiry, his daughter, Lyanna, was just dating Rhaegar. So he didn't understand the difference between ethical and legal and illegal, right? So does it make a difference whether your daughter's dating the father or whether your daughter is in a de facto relationship with Dad?
Could wind up becoming a weakness in that case. If there's evidence, for example, because there's been a pattern of domestic violence by the father in this matter,
Yes.
The issue would surely come up across is whether there's been any police call-outs or domestic violence between Lyanna and Rhaegar. And, I mean, that could place the solicitor in the position of potentially being a witness, having to give evidence.
Yes. His response is, no, I don't believe any of those allegations of domestic violence. My daughter hasn't said anything about domestic violence. I believe Rhaegar.
I don't
Sorry?
think it matters whether they believe the allegations or not, it's too close to home.
So what would you do?
Oh,
Your
as a
daughter,
solicitor?
if you were Billy Ray and your daughter, Lyanna, comes to
I
you
wouldn't
and
have
says,
touched it. Straight away. No, this is a person I wouldn't even refer to the same firm I worked in. Obviously, legal aid, yeah, but
yes,
in private practice, you wouldn't even take it in-house. It's just stupid, in my opinion. So,
anyone else got another view?
No.
No? So in this particular case, Billy Ray said to the judge, I acted for my son in a traffic infringement notice. There wasn't a problem there.
Doris, I'm talking about credibility and all of that when you're leading evidence from the witnesses. And I mean, a traffic infringement's very different when you're leading evidence on credibility. It might have been a plead guilty issue on credits, not a problem.
Right.
But if he has to lead evidence from his own daughter, who's now a witness in this case,
Yes.
aren't there a whole raft of credibility issues that he, as the father of the witness?
Yes. So if you were acting for the other party, if you were Ned Stark or the independent children's lawyer, what would you have done and when would you have taken some action?
As soon as I found out.
What would you have done? Sorry?
Well, based on the material, on the scenario, you only found out once the family report was released.
Yes. So he hadn't disclosed it until then. Sorry, you were saying.
So yeah, I mean, for me, as the ICL, as soon as I found out, I mean, I would have written to the other party,
Yes.
or to Billy Ray saying, look, I've got some concerns about this. I think it's an ethical issue, and that you shouldn't be acting. I'd ask that you consider this and you withdraw voluntarily.
Yep.
Or if that doesn't work, then make the application to the court.
Yes.
Now, we've done that a couple of times up north, and our judges haven't wanted to hear those applications.
Correct. Correct. That's exactly right. Yep.
So,
And then what happens?
I can't actually remember what happened on those. We did hear them in the end. Yeah, and we had a series of 3 happen at the same time.
Right.
One he deemed conflict, the other 2 he did not.
And so did you have to file an application in the
yeah,
case?
so required full application in the case, all the supporting affidavits. You had to point to the direct conflict.
Yes.
And he heard, I don't know, it was about a 2-3 hour hearing on the material. He didn't lead evidence from anybody, so nobody took the witness box.
Right. So was it contested?
It was contested. All 3 were wholly
And the solicitor didn't go into the...
withdraw. No.
Did he have to give evidence?
No, they filed an affidavit and that was it.
Oh, really?
Yeah.
Okay. And then what happened?
So in the one so the judge did make a decision. The one where there was a conflict, he ordered that the solicitor withdraw.
Right.
The other 2 he decided there was no conflict.
And so they continued?
And so they continued.
Successfully continued through to trial, or?
Yes.
Yep. Okay. Anyone else have a different experience? So in this particular case, at some interlocutory stage, it was raised that there was a potential for conflict, and the FCC judge said, no, there was not, and so on we marched to trial. Should Billy Ray have contacted the Law Society again once his daughter moved in with this guy, with Rhaegar? Yeah? What about the other witnesses? You know, on the fact scenario, Billy Ray knows Rhaegar's parents, he went camping with Grandad, ultimately he gave legal advice to Grandma, and then he drafted the minutes of consent order for property settlement. So, and now he's drafted affidavits by them for trial in the FCC. What about that?
He's got a problem with drafting minutes of consent because it's not clear which of those 2 he was acting for in that transaction.
Yes. Yes. And isn't the fact that he's now got a social and familial relationship with these people, doesn't that call into question his objectivity? Doesn't it call into question his capacity to be independent? You know, Rule 4, Australian Solicitors Conduct Rule, independent. What about...
potentially he could be a witness as well, in
Yes.
terms of anything that any of Dad's family might have said to him.
Yes, yes. And what about when Liana, in Billy Ray's office, rings the ICL's office? Any issues about that?
She probably had a black eye.
And a key.
Because remember in this, Billy Ray had to get a Commonwealth location order for Mum's address, right? So somewhere in his office is some confidential information. And yet Liana's in there making a phone call to the ICL, and there's...
Billy Ray's not even there.
Billy Ray's not even there,
He's
yes.
totally from the reception desk.
Possibly. So in the trial, Her Honour said the significance, this is the going camping with the in-laws, she actually referred to Billy Ray as being the de facto father-in-law of Rhaegar. And then she went further and said, you know, it puts you in the position of being the de facto grandfather of the subject child that we are all here arguing over. She says the significance being that it spoke volumes about the type of relationship that he had with Rhaegar and Rhaegar's family. There is a social and indeed familial relationship, and thus questions, said Her Honour, rose about his ability to be objective. So in the trial, we learnt that Billy Ray travelled from northern New South Wales to Brisbane for the trial in the same car as Rhaegar and the whole family, and they stayed at a hotel all together. Any problem with that?
No, it's totally fine. Jokes.
And you said this was a real case.
This is a real
This is
case.
real.
No embellishment.
No, I'm not embellishing it. This is a real case. So Her Honour raises this with him, and he says, I'll move out. I'll go to a different hotel. What do you reckon? Is that okay? Because I'm gonna be in a different hotel. No takers.
Doris, I don't know whether that in isolation for me would be a significant issue. If you're a solicitor and you're travelling with your client,
Yes.
and you're raft of witnesses, you know, regional Queensland, or you're travelling different distances,
Yes.
that I think of itself in isolation might not necessarily be an issue. Staying in the same hotel, we do that regularly with our clients where we're meeting to conference, so, but I think in the context of everything else, that's where we're all going,
Correct.
oh, that's just
Yes.
a problem.
Yes.
But it's in
Because
the
it's not
context
just
of
his
that.
client, is it? It's his family.
If it was a pure
Yes, if-
client, yeah, if it was a pure client solicitor relationship,
Yes.
I don't think I'd balk at that.
Correct. So that's what Her Honour said. It's because of that social and familial relationship. So when Billy Ray said, you know, Your Honour, I'll move out, I'll go to a different hotel, Her Honour threw her hands in the air and said that he didn't grasp the extent of how compromised he is in this particular case. Now, he drafted the affidavit of evidence in chief for Rhaegar, which talks about paying child support. You know, he's paid child support to Ella. Ella's affidavit says, I haven't had a cent since we separated. I did an application to the child support agency, but he hasn't paid, and I've been supporting my son myself. So the ICL sends a letter, right, sends a letter to Billy Ray, inviting him to provide discovery of Rhaegar's tax returns, business tax returns, because he's an electrician, he has his own business. Billy Ray writes back to the ICL, you're on a fishing expedition. I hope you're doing this to the other side as well. And then doesn't comply. Problems, anyone?
Disclosure obligation.
Right. Yes, so he does no more, he doesn't comply, says nothing more. Just before the trial, he receives from Billy Ray the updated child support assessment that shows Rhaegar has tens of thousands of dollars in arrears of child support. Now, if you were Billy Ray and you got that letter just a week before the trial, what would you do? When would you do it?
Immediately.
Right. And would you disclose it to everyone, both sides?
Yes.
What about the judge?
You would have to bring another record.
Yes.
You'd
So
have to file another affidavit because the first affidavit had not disclosed any of that. So you'd have to do a correctional thing or
Yes.
something.
yes, yes, that's right. So again,
You'd have to be clear about getting instructions to correct the record. So if you file an affidavit saying, oops, by Rhaegar, saying, oops, didn't disclose these things.
How do you explain tens of thousands of dollars?
I misunderstood.
You might have thought it was settling down the child support.
Explain it on behalf of our clients, get them to fall on their sword and then disclose. This came up, I think I was talking to, I can't remember who it was, for me just recently.
Right.
And the client wasn't giving those instructions, so the next step was to get off the record.
Yeah.
So that was the obligation. If your client will not give you instructions to correct the record,
Yes.
then your obligation to the court overrides your responsibility to the client,
Correct.
and you get off the record.
I agree. Yeah. I agree. So in this case, Billy Ray doesn't disclose it, and we are first day of trial, and Her Honour walks into the courtroom and says, Billy Ray, what's your relationship with your client? And Billy Ray says, looks her in the eye and says, I don't have one. Right? Her Honour then says, let me put it another way. Is your client in a relationship with your daughter? And he says, they're dating. Her Honour says, but the affidavit that your daughter drafted says that they're living together. Billy Ray says, I don't agree with that. I don't agree that it's a de facto relationship, Your Honour.
It's got the vibe.
Not the vibe. I don't agree. So she says, Her Honour says, it's not up to you to agree, it's in the affidavit, right? It's there. Did you draft the affidavit? And Billy Ray says, no, Liana drafted her own affidavit.
But you filed it under your name.
Correct.
So he's in trouble.
Correct. Yes. Her Honour says that she's really seriously concerned about the administration of justice in this particular case.
Did that solicitor get struck off, or?
I'm coming to it.
Oh.
So Her Honour refers to Rule 4 of the Australian Solicitors Conduct Rules, acting in the best interest of your client, having integrity, and professional independence, right? She says, Her Honour says, as a matter of the solicitor's family connections, his knowledge of them and his association with them, that is, the witnesses included, on a social level, this gives rise to a perception that the solicitor is not able to give independent judgment. She then referred to Rule 7 of the Australian Solicitors Conduct Rules, providing clear and timely advice to the client so that the client can make informed choices and decisions. The court noted that the solicitor was entrusted to hold confidential information, yeah? Mum's address for one. And she said she can't be sure when he is sitting around in social settings with his daughter and her partner, who is in effect his de facto son-in-law, so she kept coming back to that he will not disclose. She was concerned as to his responsibility to maintain confidentiality. So she went on to say, the court is faced with weighing the client's right to select their own lawyer, and he did this pro bono, right, against the duty to the court and the administration of justice. She says that she's got no doubt in this particular case the proper administration of justice has been compromised. She accepted the ICL's submissions about the conflict of interest and then directed that he withdraw from the case. The case was set for 3 days. We went 1.5 days of contested hearing over whether he was in conflict or not. And after Her Honour's ruling that he withdraw, there was then an application for indemnity costs against the solicitor personally, and we were successful in that as well. So the take-home message, I guess, about this is be alert as to whether a particular set of factual circumstances brings you into conflict with your ethical duties. If you're in doubt as to whether you're in breach, then refer to the Australian Solicitors Conduct Rules, speak to a senior lawyer, contact the Ethics Centre at the Law Society, all of the above. Any questions about this? No? Yep.
Did you find out about the child support situation through the subpoenas, or did he eventually decide?
No, so what happened in this particular case was after Her Honour, the first thing she asked when she walked into the courtroom was, what is your relationship, right? And from there, it just unravelled. So this solicitor ended up giving evidence, because he was being cross-examined by the judge. in relation to his conflict of interest. And in the course of it, he then said the independent children's lawyer, this was actually my case, so he's like, she caused me to do this, right? So Her Honour made a finding that I had acted quite properly in raising all of these issues with him from very early on, but he chose not to take any action about it because he said he'd already been to the Law Society and they said that it was not advisable, but that it wasn't illegal, so he completely misunderstood his ethical obligation. Sorry, did I answer your question?
No, I just wondered how you found out that he'd received the letters about the
Well,
child
in
support.
this cross-examination, he and trying to put the ICL into the heap, it came out that I had asked him about tax returns and child support and so on, because I had seen in the evidence Mum saying I don't get a red cent and Dad saying I'm paying, and Dad also saying I'm going to pay for this child. If I get final orders, I'm going to pay for this child to come to northern New South Wales to spend block time with me. So there was a question about his capacity to pay. And so Her Honour, in her interrogation of Billy Ray, then talked about child support, and it completely unravelled, and then he said, I've got this letter, la la la, and the child support was like $20,000 in arrears, which you can't explain. Yeah. So she asked him, why did you draft this document that says he paid child support? And his defence to all of that is, he did. He paid child support like in that first month after separation. Oh.
What about a whole truth rather than
Exactly. So he was cherry picking, but that's essentially what he said. That well, the father did, but Her Honour's like, well, no, he didn't pay after that. Oh, but he did. He did. He paid for a month, and Her Honour said, but that's not what your evidence is. It doesn't say paid for 1 month, didn't pay for 4.5 years. Yeah.
Was he a sole practitioner?
He was a sole practitioner.
Yes.
Yes.
Is he still a sole? Too soon to tell.
I don't know. I can't answer that one yet. I don't know.
New South Wales Law Society or Queensland Law Society?
New South Wales Law Society. At one stage, Her Honour was so concerned she stood it down, and for him to go off and have a think about what she had said and so on. And I rang the office going, check to see if he's got a practicing certificate. Because he didn't understand the difference, between ethical and legal and illegal. Anyway, the office says, no, he's got a practicing certificate. Anyway, we resumed, court resumed, and then just before lunch, Her Honour then goes, it must have hit her too, because she goes, I want to see your practicing certificate. After lunch, you need to produce it, la la la. So, yeah, it was quite crazy, really. Any other questions?
Doris,
Yeah.
what did Her Honour adjourn for in the hope of, standing it down? What was she hoping
stood it
would
down.
happen? For him to go and think about it.
For him to go and think about it, and for him to have a conversation with his client. And then withdraw. And then withdraw, but he didn't. Sorry, yes?
Can I ask, with the incident of him disclosing under cross-examination the information about the child support letter, I'm assuming at that point he didn't have instructions from his client to disclose that.
No.
Was there a specific direction from the judge to answer those questions or to disclose
Yes.
that information?
Yes. So, good question. It's a good point, actually, because no, he didn't have instructions, and at one point, when Her Honour was addressing him about the difficulties in cross-examining his own daughter, he then said, okay, I'll withdraw the affidavit. He didn't turn around and get instructions. He just stood up and said, I will withdraw the affidavit. So Her Honour then went, oh, wait a minute, you just did that without instructions. Where is this going? This is the problem about you acting, because your role as the father, de facto father-in-law, and your role as the solicitor was just completely twisted and meshed, and you no longer could be independent and advise your client properly. So yeah.
I think the scariest part about that story, though, is that he didn't seem to understand or didn't care.
Yes, I think he didn't understand because he kept saying it's not illegal.
Yeah.
He didn't understand his ethical
And I'm assuming because
obligation.
the witness was his daughter that he was an elderly gentleman.
Not really. He didn't look that old.
Yeah.
Um,
That's a bit scary.
yes.
Was he charging his client?
Sorry?
Was he charging?
No. Pro bono. It was pro bono.
Was anything raised about the social worker from the prison having sex with an inmate?
We didn't get to that part of the conversation. Simply that she.
Their professional obligations as well.
Indeed. Nobody disclosed. Nobody disclosed that. Just that they had met, there was an interest, but that the relationship developed after he was released from jail. Yes, of course.
Did you write to the Law Society or did you leave that to him to get that, seek that guidance? Did you at any time write to the Law
I
Society?
didn't write to the Law Society. So in this particular case, I went to 2 other lawyers initially saying that I believed that there was a conflict of interest or a potential conflict of interest, and neither of those other lawyers agreed with me, which is why I'm here talking to all of you, because, yeah, I mean, this is very early in the piece, right, before all the other evidence sort of unravelled, but very early in the piece, once I knew that Liana was his daughter, I was just like, oh, I think, yeah, bells, the bells were ringing, danger, Will Robinson, but no, nobody else agreed with me.
Dosh, you said you raised it with the court, but as the ICL, did you just raise that like at a court date, or did you file an application?
No, we raised it at a court date.
Yeah.
Yes, both myself and Ned Stark had raised
But
it.
Ned Stark didn't make an application?
Ned Stark didn't make an only an oral one,
Yes.
Yeah. but that particular presiding judicial officer didn't agree.
So how far back did you line him up and start writing to him about
So as soon as I found out at the interim hearing, when he told me Liana's his daughter, I then pulled him to the side, had a conversation with him, said the same things that, you know, the potential for becoming a witness in the case, what if there's DV later on between your daughter, between Rhaegar and your daughter, and she's the victim, la la la. He said, no, there's no DV. He didn't believe that the father was a perpetrator of DV. And even though we subpoenaed, you know, subsequently subpoenaed records that showed he had this history, he still didn't accept that evidence for whatever reason.
what did you have to demonstrate? Did you have to demonstrate that he warned him at an early stage, or that just
Yes, so for the costs order, I produced the initial letter that I had written to him, asking him to withdraw. And just before the trial, probably a month before the trial, I'd sent him another letter saying to him, I'm really concerned about your position. I'm concerned about the potential for, you know, the court to say that there's a conflict here. If you are removed at any stage in the course of the final hearing, and this jeopardises the hearing, I will be seeking costs against you. So all of those letters were actually produced, to support the application for costs, and I got just under $14,000.
Real money.
Real money. Yeah, Nikki, right? Real money, yeah.
Because you paid it.
Yeah, he did.
Good on him.
Yes. Perhaps, yes. Any other questions? Yes.
So, I mean, I take a slightly different view from the majority in that I would have said at the beginning that it was probably okay, not particularly wise, but not once it got to the point to do maybe as much as just the location order, and then after that to tell, you know, to save costs, I suppose. But at that point, you know, it was pretty obvious that there were all sorts of things that could happen, even if they weren't going to. But what I was going to ask is, as I would always, when I had clients, regardless of whether there was any, you knew them or anything else, kind of do a little bit of cross-examining myself at the beginning. So if you get enough, if he was still acting when he got that affidavit from her saying there was no child support
Yes.
paid, surely he would have been up to him to go a little bit further than say, and I know he eventually turned out that he knew that it was only for the month, but let's say he didn't. Let's say that he got told, yes, I paid child support.
Yes.
Wouldn't you, as a competent solicitor, say to him, well, let's get some evidence of that. Can you find, and the same with the DVOs, surely he could have got his authority to do a search and find out whether there were any. I mean, without.
Highlights how compromised.
Yes, but I think in this particular case, Her Honour was right. His own sense of judgment as a lawyer was completely clouded by him being the father and him wanting his son-in-law to do his very best to get the order for time spent. It really did affect his professional.
So I mean, if he'd done that at the beginning, it would have been obvious that there was definitely that it was more than a potential conflict. It was
correct.
Yeah.
Correct. But even before trial, if he had bothered to look objectively at the subpoenaed material, the evidence was there of him having a propensity for domestic violence. There were breaches of domestic violence. So just because he hasn't hit Liana doesn't mean that he isn't violent. And there was evidence there that he had been violent to the mother in this case, and there were police call-outs.
And was he in prison for breaches of DV or for other stuff?
No, for other stuff.
Other stuff, wow.
Other sorts of violence.
Just on that comment that was made about getting a location order, I think the minute he said, I accept that address, he was, like, he should have never, like, that's when it should have ended. He should never have accepted that address. Because he's compromised, yes, it's his son was a partner, so he's actually getting that information about where the mother was.
Yes.
I think was unethical.
I think that was sort of in the judge's mind about confidentiality and his ability to maintain his confidentiality. Her Honour didn't even deal with the fact that Liana was ringing the ICL from the solicitor's office, so, thank goodness. So, any other questions?
If there's no other questions, we might finish up now. We're just going to have a quick afternoon tea, and then His Honour Judge Jarrett will be coming to do this afternoon session. I'd just like to thank Doris for that very So it's just a short 15-minute afternoon I did do.
That's fine, they have insurance. Maybe thought we catch the bus. As we wait here outside, I'll run out somewhere, I'll bring a lawyer in
No one can use it. So I'm stuck with classes that are okay.
Well, I thought.
She's actually yeah, so I wrote to them and said that she had no capacity. We're having some trouble with
Oh, do you have to drop over nose here? Oh, so yours is just a...
I was wearing these glasses and I should have just read them. And they wrote that. That's been really struggling. There's something about the do not wave out getting a sword. But it was because of the nose piece.
back to really rough. But I didn't realise that. Well, of course you don't. You don't go back and have a look at them. It's sometimes it's the motivation and the
You guys really tough, but you guys all got them to apply for like we could actually contact their straight away.
I like cheap things. I've had cheap glasses and they break. I must be too rough. So I went, mine are that much because I've got multifocal lenses. And then that's what they said to me reading. And they said, do you want to go to multifocals? Oh, no, I just don't want to have that. It works. I got used to that. It was really hard walking up the stairs. Because you don't know quite where to look. The lens, everything else is actually share it. Not that it's nice. It's pretty let's go eat. You don't see that? No, I just can't do it. Can't do it. Like I'm intolerant, so if I have a bit, it's okay. And then sometimes it's not. It's okay. Oh yeah, you maxed out. Yes. Two's okay. Three, hit the limit. Yep, I'm guaranteed. Living with keep sending me needless to say, I was first and I had no idea
We want to bring this
and they weren't friends on Facebook, anything like that. I think
it's alright, I mean, if they're too
my sister, I don't think I have
It's up to you.
But anyway,
Yeah, so you don't confine yourself to disappearing.
Yeah, she said to me, but my sister said she's going to leave boys from legal aid. I said, what? And that's like, yeah, my sister said she's going to work with
We are lawyers.
well, if that's the case,
Just having everything set to me, and then
Monday went straight into my boss's office, working here for a year, and I just said, oh, I need to, I don't know what to do, like we need to get her out.
I noticed you were actually handwriting and see the smartphone where the big button when you press that it actually converts it into and actually converts that form into an email that feeds directly to it's kind of like like when it's from electronic, it's getting all the details of the actually converts it and send it into you as well. And so I just said
Yeah, I know. No, I know, but even just the thought of something. But halfway, yeah, and then it turns out she's got a brother. And I'm like, what is his full name? Stay away from the
Actually, the whole like.
Wow.
Because I've worked in this is a dream way. It's popped up where I didn't even know it was happening until halfway through the winter. Someone they lost and they were talking about fishing business, and I remembered the name of the fishing business because it was like a funny name, it was like Whale or something. And I was like, oh, this is the father of that kid. He said, oh, she'll just oh, she reckons she's over. And then I said, oh, I'm just going to stop there. Which is going to be check something that I have. And then I rang my husband and said, hey,
The home secret goes.
Until that, well, like fishing business, we did the property sale. And then the child thing was still ongoing. And then it's on the report. But yeah, then I had to go back and say, I'm so sorry, I had to cut you short. But because you didn't get full advice, we'll just consider the phone advice. Especially for guys. And Sue, because Sue's basically been there forever. She's like, doing like the families from there. So many conflicts. Like, I represented her neighbour in the dispute and then nearly bought his house when he broke up his wife. Didn't realise it was him until we found out who his son was through the agent or something. Sue told me, she's like, oh, that's my neighbour. And I'm like,
So when will they be filed?
It just felt dirty though. It felt dirty. I was like, no, I'm not like that house. Because he crashed it.
So when is the
Yeah, we got snacks today.
So it's not
Not that I need any of it.
So they wait till Monday when I got back and he says it's like,
She was so yeah, we did have conversations with her.
Have you got a deal?
It's on I try to get the ball, but then she used to get the ball. So thanks all for coming back from afternoon tea. I'm here to introduce His Honour Judge Jarrett from the Federal Circuit Court. Judge Jarrett is probably known to most of you, at least those from Brisbane. To those from our regional centres, Judge Jarrett is a judge who sits in the Federal Circuit Court, mostly in the family law jurisdiction, but also does the other federal jurisdictions. He's been appointed as a federal magistrate in 2004, February 2004, into the Federal Magistrates Court as it then was, and so he's probably the most senior Brisbane judge in the Federal Circuit Court currently. He's been invited along to talk to you today about how property proceedings work in the Federal Circuit Court. So welcome to Judge Jarrett.
Thanks. Because some of you know me, I brought my two associates along just to crowd control purposes. So if things get out of hand, you're on the job, boys. Now, a couple of things. When I was asked to speak about speak here, they said, "What do you want to talk about?" We'd like you to do something about property because legal aid, as I understand it, getting into the property game. So it was suggested perhaps a bit of a talk about how property cases are managed through the FCC. But I'm not going to talk about that because how cases are managed through the FCC, property cases, and how all cases are managed through the FCC is a work in progress. You might have noticed that we've been doing things a little bit differently in the last little while. We've got this pilot thing going. But all of the judges in Brisbane are meeting tomorrow, in fact, to discuss the future of that. And it it might be that it continues, but it's more likely that it probably won't. And if it does continue, it might continue in a slightly different form. So just exactly what's going to happen, I'm not too sure. So I see that I don't see that there's much benefit in going through the process that we're currently going through, if that's going to change in the next little while, in the short term. So when I explained that to the person who I was speaking to about this, and I said I'd just have a bit of a ramble around the property jurisdiction, she thought that was a great idea. But she thought it was less of a great idea when I told them to make sure that everybody's got their rules with them. Who brought their rules? Oh, good on you.
Nikki had them this morning.
I had them there somewhere around here. I haven't got a PowerPoint or a paper because I want you to pay attention. If you've got a PowerPoint or a paper, people drift off. I've done that. You drift off, you look at what's on the screen, you think, yeah, I'll look at that later. And then you never do. It just goes in the drawer. And I'm a bit lazy. I don't do papers anyway. So, property applications. There's some interesting cases that have come out recently about property and about commencing property proceedings. The starting point to think about in property proceedings are the pre-action procedures, yeah, in the federal law rules. Who applies those in their property cases? And then starts proceedings in the Federal Circuit Court. They don't apply to our court, so you don't have to go through them. They're a creature of the family law rules. They apply in the family court, but they don't apply in our court. You might think that's strange. I agree, it is a bit strange. But it's a throwback to when our court was established, and the notion was that it would be a cheaper, faster alternative. Commence your proceedings, you have one court date, you get a trial and the thing's over. And in the early days it might have worked like that, but not now. So most people that come to our court talk about having one side not complying with the pre-action procedures, but they don't apply in our court, so there's no point talking about that. There's an authority in the full court that confirms that. I've forgotten the name, and I was going to get my associates to look it up, and I forgot to ask them to do that. So I can't give it to you, but it's a decision of Justice Watts in Sydney. I thought I nearly had the name then. But he confirms that the pre-action procedures don't apply. So when you commence proceedings in the Federal Circuit Court, you commence it by filing an application. And most of the applications, of course, are filed over the internet now, through the portal. And you can file documents at any time of the day or night. Whoever dreamt up that idea needs to be shot, because you arrive at court, you would have seen it, you arrive at court, we filed this last night, Your Honour. Fantastic. I was just waiting to get it. I was sitting by my computer. It arrived a bit early. It came at midnight. I wasn't quite ready for it. So you can file it at any time of the day or night. If you file something at night time, say 7:30 or 8 o'clock at night, when is it filed?
The next day.
Is it?
Next business day.
Why do you say that? I can't hear anybody. Why do you say that? You're correct. 4:30. The rules say 4:30. If you file it after 4:30, and in fact our rules are different to the family court rules, and they're different to the federal court rules. We all have electronic filing now. We all have different rules. And our rules say that if the transmission is not complete by 4:30, then it's taken to have been filed the next day. Who's read that recent federal court, full court of the family court decision about filing overnight in property cases?
Is that the one where the party passed away?
Yeah.
Yeah.
Yeah. Read that? That's what this is all about. So you file at, say, 7:30 at night, and then the other side passes away at midnight, before midnight. Have you filed in time or not? No. That's the conclusion the full court came to. That's the conclusion they came to. But, and I'll walk you through that case in a minute. The documents that you file, you would have seen me in court, no doubt, those that have had the pleasure. of taking people to task on their applications for property adjustment because of the form of the orders that they're seeking. You'll see that form in the property application. The applicant seeks that there be an account taken of the matrimonial property and that it be divided 60-40. You seen that? Don't do that. I'll make you do it again. Some other judges don't. I'm not responsible for them. I'll make you do it again. And that's because a claim in that form doesn't seek any orders that the court can make. The jurisdiction that you're asking the court to exercise, the one that you're trying to invoke, is a jurisdiction to make property adjustment orders. Not just orders about property. There's a difference. Property adjustment orders adjust the interest of parties in property. There's a discussion about that in Stamford, and there's a discussion about it in Hickey. You're all familiar with Hickey, I take it. There's a discussion about it there, and the discussion in Hickey comes about in the context of those catch-all orders, you know, the ones you see at the end of the orders that say, and the husband gets to keep everything that he stands possessed of today, and the wife gets to keep everything she stands possessed of today. And the full court says they're not property adjustment orders unless the property that's dealt with by those orders is jointly owned. If it's jointly owned and the order says the husband gets to have everything that he's got, well, that works a change in the ownership of the property. It moves it from joint ownership to ownership by the husband, yeah? And that is a property adjustment order. But where everybody just keeps what they want, what they've got, and, you know, let's talking about chattels or motor vehicles or whatever, who would know whether it's jointly owned or not, frankly? They're not property adjustment orders. So the full court says that in Hickey. They're not property adjustment orders. They're usually included, and they're included for a good reason. You know, you might be sitting around in front of the fireplace one day going, oh, what happened to that piece of art that was hanging on the wall? Who got that in the property settlement? There's no orders about it. Let's go and get another one. It's designed to avoid that sort of thing, you know. So you need to ask for property adjustment orders. If you don't, then the proceedings are no good. You just can't ask for an order that everybody keep what they got. You've got to find an order that adjusts property. There's another way you can get jurisdiction, of course, or to engage the jurisdiction, and that's to ask for a declaration. That engages Section 78 of the Family Law Act rather than 79. And some people do that, particularly where they've lodged a caveat over some real property. They need some proceedings to support the caveat, yeah? And so they issue the proceedings with a declaration. That form of orders that I was talking about, you know, that there be an account and the proceeds divided 60-40 or whatever, that got some attention in the full court in a case called Shaw and Shaw. Is anybody familiar with that one? Shaw and Shaw, 2016, FCA FC 159. Nobody's writing this down. It's important. Shaw and Shaw is a case where a judge in our court, in the Federal Circuit Court, made the property adjustment orders that the parties asked for, or that the applicant asked for. And I'll just turn them up. The orders that His Honour made were these. 1, these orders are made by way of alteration of property interest pursuant to Section 79 of the Family Law Act. 2, in full and final settlement of property issues between the husband and the wife, the assets of the husband and the wife be divided between the husband and the wife as to 65% in favour of the first respondent wife and 35% in favour of the applicant husband. 3, there be liberty to the husband and wife to apply in relation to consequential orders. 4, the cross applicants, there was a cross applicant in that case, that application be dismissed. That was it. Who's seen orders like that, people asking for orders like that? We all have, I'm sure. So this judge finally said, well, if that's what you want, that's what you can have. And so they got it. And the full court said, we understand your frustration, but that's not a property adjustment order. So the full court in that case was, this is an Adelaide case, so it was Justice Strickland, I think. Justices Thackeray, Strickland and Ainsley Wallace. And so they say this, they say it is undeniable that these orders do not, despite Order 1, affect an alteration of the property interests of the husband and the wife pursuant to Section 79. No order requires an adjustment to the interests in the marital home, nor requires the payment to the wife, or from the wife to the husband, of funds equivalent to the percentage division referred to in the orders. There's just nothing to carry through the division. they are, in their terms, unenforceable. They provide no machinery orders. And so they went on to say we need to set those orders aside and we need to make some other orders. But they did, when they did that, they reminded everybody about just what property adjustment orders are. They referred to this passage from one of the older cases called Mullane and Mullane, which I'm sure you've read in the High Court. It says this is the High Court talking. In our opinion, therefore, Section 79 on its proper construction refers only to orders which work an alteration of the legal and equitable interests in the property of the parties or either of them. An interest in property is a right of a proprietary nature, not a mere personal right. It does not exclude every interest which is not assignable or transferable. Thus, an order under Section 79 may give rise to an interest in property which is defeasible on assignment or transfer to a third party or on the occurrence of some other event or which the holder is enjoined from assigning or transferring. So it's got to be something that transfers or changes ownership. Yeah? So, in Shaw and Shaw, they said the trial judge's orders were no good, they set them aside. They also said this, they said that the liberty to apply provision doesn't assist. Now, this is just a little sidetrack. Liberty to apply. Who wants to have a crack at what that means? Come on. Come on.
If there's a problem with the implementation or interpretation of the order, it's not carte blanche to go back and get a different order.
Any other attempts? Come on, got to have one from this side of the room. Yep.
Does it just mean you can bring an application?
Yeah. Liberty to apply provisions are about the mechanics of an order. If you go back and look at the old cases, they're all about the mechanics of an order. It's not you can come back and ask for anything whenever you like. And often people will say to us, Your Honour, can we have liberty to apply? You don't need it. If you want to bring an application, you file one and it gets dealt with. Liberty to apply in an order is liberty to apply in respect of sometimes interpretation, but mainly in the mechanics of the order. And you'll see that there's a bunch of cases, Mullane and Mullane is one of them, I think, where the distinction between the substance of an order, a property order, and the mechanics to carry it out is made. And the liberty to apply applies to the mechanics of the order. Anyway, that's just a little aside. So, you've got your application, you're going to set out the orders that you want. You don't want to set out any of this nonsense. You set out the orders that you want that are going to adjust property, the ownership in property between the parties, and then you file your application. You file it over the internet, and the respondent dies. So that brings us to this case called Frost and Wootton. This is really interesting. 2018 FAMCA FC 177. In that case, that's exactly what happened. The husband, I think it was the husband, got injured in an accident, went to hospital, was critically ill. The wife filed some proceedings for property at about 7:30 that night. And this is what her application said. Her application contained an application. Now this is in a family court, bear that in mind. She asked for these orders. I'll just turn them up, hang on. That the applicant wife be excused from particularising her final orders sought until after the respondent husband has made full and frank disclosure in this matter. Who's seen that before? Yeah, I see that all the time too. Is that a property adjustment order? No. Full court said that's not even close to a property adjustment order. So you would think, wouldn't you, that if the application was filed over the internet, filed anyway, and it included, that was the only relief that it sought, it would not be a valid application? The law is very mysterious, isn't it? Because the full court said it was. And they said it was because she ticked the box at the front that said she was asking for property orders. So the form has those boxes on the front, and you can tick the box, you know, parenting, property, maintenance, blah, blah, blah. She ticked the property maintenance order, and the full court said that was enough to signify the application as one which was asking for property adjustment. That had the effect of notifying everybody that her claim was one for property adjustment. That was a matrimonial cause under the definition in CA of matrimonial cause, and that was enough to make the proceeding valid. I'm told there's a special leave application. It hasn't been dealt with yet. There's a special leave application in relation to this decision, so we'll see what the High Court thinks, but the application was a valid one in that sense. So notwithstanding that she'd put nonsense in her claim for relief, because she ticked the box at the front, it was a valid application. So make sure you tick the box. That's the takeaway. That's the takeaway from that. In fact, I had previously written a judgment, not a little bit before Frost and Wooten. I don't think it was published. It's called Kent and Golder, 2017 FCCA 1621, where I was faced with a similar case, and the respondent had applied to strike out the applicant's proceeding because the applicant had asked for similar sort of orders. You know, we want to tell you really what we want once we've seen what the other side's got. And I said that wasn't a proper application. Didn't seek proper property adjustment orders, but I concluded that the application was not a nullity, and so there were proceedings before me in which I could make other orders to regularise the rest of the proceeding. That's pretty inelegant, but one of the arguments, which I've got to say I encouraged to be made, was that because the relief that was sought in the application was a nonsense, the application itself was a nonsense and a nullity. And if the court has a nullity before it, there's nothing to support the making of any other orders in that proceeding. Ultimately, when I reflected on it, and with the benefit of counsel's argument, I concluded that was wrong, and that the proceeding had a formal defect in it, which didn't invalidate the proceedings. And that was the same conclusion the full court came to in the Wooten case. The full court decided that the proceeding, even though it didn't seek any proper relief, it wasn't a nullity. The argument in that case was that the trial judge, Justice Cronin as it turned out, had dealt with the respondent's application to strike out the proceedings because it had been filed on the 7:30 of one night, wasn't deemed to be filed until the next day. In between, the respondent died, and you have to have a live respondent to have proper 79 application. So the proceeding couldn't be resurrected. It was a nullity when it was filed, and couldn't be resurrected. And the full court said no. Justice Cronin was right about that. You could resurrect the proceed. Sorry, you couldn't. Start that again. He was wrong about that. You couldn't resurrect the proceedings. Once the person had passed away, the proceedings truly were no good, and you couldn't use the rules to extend the time to commence the proceedings or anything like that. It all fell away. So there's a couple of messages out of that, I think. First is make sure your proceedings actually seek a proper order and you won't run into any of these arguments. You won't have to bother. Second, file before 4:30 and you won't have that trouble either. And if you must file, late or at night time, do it with a healthy respondent. One of the interesting parts of Wooten was that there was no consideration. I've never really thought this through, but there was no consideration given to the old practice of commencing proceedings after hours. You used to be able to come down to the registry. You'd ring up the registrar and say, "Look, I've got something to file. I need to file it today." And if you paid some exorbitant sum of money, they would keep the registry open for you, and you could then file it. And it was then taken to be filed when you filed it, and that saved all of these arguments. With the advent of e-filing and the ability to just do it whenever you want, that has fallen away. That isn't a practice that it's adopted anymore. But it's something that the Rules Committee, or at least of our court, is now going to look at pretty closely to try and get some rule in place that deals with this sort of anomalous situation. You would have seen recently that there's a committee that's been established by the Chief Justice of the Family Court and the Chief Judge of the Federal Circuit Court to regularise the rules between the two courts, to harmonise them, as it were. I'm told that's going all swimmingly well, but we won't see some harmonised rules for a little while. I'm not on that committee, thankfully. So watch that space. You'll get some new rules soon. So that's Frost and Woody. You've filed over the internet. The application has got proper orders in it. You get your first court date, and then you come along to court on your first court date. And the respondent doesn't show up. What do you do then? You've served the respondent. Sure, you prove service. Let's assume you can prove service. Assumption that's not always well made, but let's assume you can prove service. What do you do? What are you going to ask the court to do? The respondent's not there. Anything? Nothing? This is like being in court.
Might be able to proceed with your interim application.
Your interim application, what are you applying for on an interim basis?
Well, it could be you're applying for the sale of the property, you could be applying for some division, you could be applying for an amount of money to proceed with your legal proceedings.
Yeah, you can do all those things. Who's asked for the respondent, for there to be an order that the respondent appear personally? Not game to admit to it, eh? Because you see that a bit. I've seen orders, in this new process we've had, I've seen lots of other orders made by lots of other judges where they've ordered a respondent to appear personally in a property application where they've never filed a response. What do you say about that? Good, bad, can do it, can't do it? I'm not going to tell anybody what you say.
If you've given sufficient time for the respondent to file response material, you've proved service, you've given sufficient time, couldn't you seek final orders in their absence?
Sure, we'll get to that. My question is, can I make the respondent come along by ordering them to appear?
Warrant? Yeah, I don't think so. I don't have to order a warrant, so we can't ask for that.
Can't ask for what?
We can't ask for an order in our application that is physically present. It has to be, the court has to
You
order
could
a
ask. My question is really designed to figure out whether a judge can do that. Can a judge order a person to turn up? I think the position is this. I don't think a judge can order in a property case like this a respondent who hasn't filed a response to show up. It's a free country. You're not obliged to participate, are you? We're not at the point where you have to come along, and if you don't come along, the judge is going to get a warrant, and although some have, to get you arrested. If you don't want to participate in your property proceedings, you don't have to, and you can't be made to. So that causes some people a bit of difficulty when you point that out to them, because they say, well, how are we going to find out what the other side's got? They haven't cooperated with us at all. We've got no disclosure from them. What are we going to do? Well, that's what you get paid the big bucks for, isn't it? To figure that out. Because you can't force somebody to come to court if they're not, if you know, it just seems to me unconstitutional. You know, it's the vibe to make people come along if in a property case. It's like being sued in the civil courts. It's like being sued for a debt. Oh, you know, Your Honour, the respondent or the defendant isn't here. I'd like you to order them to be here. The judge over there would look at you and go, what? No, you can have judgment by default, but I'm not going to order them to be here. We're not at that point yet. So, if I were you, I wouldn't be asking, at least me, to order the respondent to turn up. Let alone issue a warrant. Let alone get somebody arrested by the police just because they haven't answered their property application. Goodness. So, default, yeah? Default orders? When's somebody in default in the Federal Circuit Court? Any ideas? This is where you get your rules out. It's all in here. It's all in here. So you go to Rule 13. if you go to Rule 13, you'll see that there are lots of rules there about various things. There's a lot of rules in here. 13.03 capital A talks about when a party is in default. And 13.03A1 talks about when the applicant's in default. And 13.03A2 talks about when the respondent's in default. And a respondent's in default when a respondent hasn't satisfied the applicant's claim. That's the first thing. Secondly, fails to give an address for service before the time for the respondent to give an address has expired. So what's that, 28 days after service, I think now? In default if you haven't filed a response within the time. In default if you haven't complied with an order of the court in the proceedings. You're in default if you haven't filed and served a document required under the rules. Again, if you haven't filed a response, that probably catches you there. And in a property case, you haven't filed your financial statement or an affidavit of financial circumstances, that catches you there. Or you haven't defended the proceedings with due diligence. That probably counts as well if you don't turn up on the first court date. So if you turn up on the first court date, the respondent hasn't filed anything and they're not there, then you'll be able to establish that the respondent is in default. Okay? But you need to do it by reference to the rules. Once you've established that a respondent is in default, what then? First court date, the respondent's not there, the judge has just found that they're in default. What do you do then? First thing you need to do is to understand what orders the court can make on default. And they're in the rules as well. Order 13.03 capital B provides for the orders on default, and there's a whole bunch of them. Some apply if an applicant is in default, some apply if a respondent is in default. And if a respondent is in default, then the court can give judgment or make any other order against the respondent that the court thinks is appropriate. Default proceedings like this have attracted a lot of attention in just about every court in Christendom over many years. And there's a lot of law about what a court has to be satisfied of to give a judgment by default, or to make an order in default. And it depends on the nature of the claim, for a start. In the civil jurisdiction, of course, if you've got a claim which is a liquidated suit or demand, I think the old term was, or the old phrase was, then you can proceed in a certain way, and the registrar might be able to give you judgment for the amount of your claim plus interest plus costs. In the equity courts, if you were claiming equitable relief, you had to support the relief that you wanted by affidavit, and there needed to be an affidavit that went with your originating summons that set out the facts upon which you said you were entitled to relief. In a common law action where there was a pleading, for example, a statement of claim, defence of a statement of claim, then it used to be the case that you would have to call evidence to demonstrate that the matters you pleaded in the statement of claim were true, or there was evidence to support them. And then in a damages action, you'd have to lead some evidence about your damages. That's sort of changed a little bit. The rules have changed over the years, so that presently now in the federal court and in the federal circuit court, in the non-family law jurisdiction, for example, if you commence your proceedings by application and statement of claim, and the respondent's in default, you can get judgment based upon what the judge thinks you're entitled to just by reading the statement of claim. You don't have to file any evidence at all. So you first have to understand the nature of what it is that you're dealing with before you can decide what orders you're going to get. The jurisdiction in family law comes from the old ecclesiastical jurisdiction, yeah, in the High Court of Justice in the UK. Not quite an extension of the equity branch of the law, but pretty closely related. And proceedings there were done by summons and affidavit. And that has flowed through even to today, where proceedings in our court, application and affidavit, in the family court, an application, eventually affidavit or affidavits. So that's an inequity proceedings in other courts, Supreme Court of New South Wales, Supreme Court here, an application of some sort supported by an affidavit rather than a pleading. So what you want and the evidence you want to rely on to get it. Our rules provide, you would have read them I'm sure, that when you file proceedings in the family jurisdiction, you file an application and you file an affidavit that sets out the facts upon which your client relies to get the relief that they seek in the application. Yeah, that's Rule 4.01 or 2. Yeah? Who actually does that? Yeah, that's what I thought. If you do it, it helps. I've had over 15 and a half years, 2 occasions where I've been able to, on the first court date, give judgment by default in a property case because the affidavit has set out all of the things that it's had to set out. Here's the property, here's the valuation we got, here's this, here's that, and it was all there. It was like, it was like a book, but still, I could do it on the first court date because the evidence was there. That's the Rolls Royce. Not every case is going to get the Rolls Royce treatment or is able to get the Rolls Royce treatment, but because those cases did, I was able to do something on the spot. So you come along on the first court date, your affidavit's not quite right. What Marianne says is right. You need to think about the evidence that you're going to use on the default hearing. And a lot of people come along and say, well, we've sworn to the values of things in our affidavits or in our financial statement. Is that good enough? No. Well, why do people keep asking me to do it? There's a decision, let me just find it. Find this one. The decision where a case called Zane and Allen, full court decision, 2008, FAM CAFC 115, where the full court was called upon to examine a trial judge's decision made after an undefended hearing. The hearing before the trial judge proceeded on an undefended basis after the respondent repeatedly failed to comply with certain orders and directions. So it was a slightly different case. It wasn't non-appearance, it was default because they weren't going to disclose and comply with some directions. And the trial judge in that case went through these guidelines in relation to undefended hearings. In an undefended case, the response becomes a nullity. So that was a case where there was a response. We're dealing with one where there's not. Where an application has been struck out due to the default of a party to make a full and frank and prompt disclosure of his or her financial affairs, that party ought to have no further right to be heard without order of the court. In an undefended hearing, the applicant has a duty to the court to make full disclosure and deal with the court in good faith. So, in that context, full disclosure is not talking about full and frank financial disclosure of your position, but it's talking about full disclosure in the sense that is often described in cases involving ex parte injunctions, that sort of thing. If there's anything adverse to your case that the court should know about, you've got a duty to tell them. You've got a duty to fess up to it and say, this is against me. Okay? So you've got that duty. In an undefended hearing, the applicant must establish the case with admissible evidence. Again, harking back to the ecclesiastical way of doing things, application, affidavit. The affidavit must be admissible evidence. It's as if it's a final hearing. In property cases, do the rules of evidence apply?
Yes.
You've got me here to aggravate me this afternoon, haven't you?
Yes, it's not, Division 12A is only about parenting.
Yeah, yeah. Although Division 12A can apply in property, can't it?
If Your Honour makes an order applying it, is that right?
Don't know, I haven't read it. I think it's if I make an order and everybody else agrees. I think everybody's got to agree, but who's got Division 12A here? You've got your axe here? Surely. Oh, my goodness, right. So they don't, Division 12A, you're right. Division of 12A in parenting proceedings says the rules of evidence, or some of the rules of evidence don't apply, not all of them, some of them. And you can apply that to property proceedings. But if there's no declaration or direction under that section, then the rules of evidence apply. On a final determination, the making of a final order, can you use hearsay evidence? Can't hear anybody. It's people saying things, but I can't hear it. Sorry? No, you can't. Unless you engage the exceptions in the Evidence Act about the use of hearsay evidence, which requires the giving of notices and all that sort of thing. I've never seen anybody give a notice. In any case, in a bankruptcy case or in a trade practice case, in any case, I've never seen anybody give a notice to engage those mechanisms under the Evidence Act to make hearsay evidence admissible. On a final hearing, final orders, hearsay evidence is not admissible. It's got to be direct testimony. It's got to be evidence from the valuer. It's got to be evidence from such and such. If you're asking the court to make default property orders, are you asking the court to make a final order or an interlocutory order?
Final.
Yeah, it looks like that, doesn't it? But it's not. It's an interlocutory order. There's lots of cases in the federal law jurisdiction and in the state jurisdictions that talk about the difference between a final and an interlocutory order. And an order or a judgment by default is generally seen, without exception I think, seen as an interlocutory order. Even though it determines the rights of the parties finally, seen as an interlocutory order. There are plenty of cases, they're not hard to find, they're out there. So what does that mean for the little discussion we've just had about admissible evidence?
Someone could come back under the slip rule.
No, so you're jumping ahead. We just went through saying on a final hearing you can't use hearsay, but if this isn't a final order, so that means you can get the valuation from the valuer and put it to your client's affidavit. It's hearsay when it comes through your client, yeah? And you can do it that way because it's an interlocutory order. Bear that in mind because that's important. I've often had solicitors say, well, it's going to take us forever to get an affidavit from this person, affidavit, blah, blah, blah. No, you don't need to do that. Just get a letter, a report, or something. It needs to be some evidence. And it can go in as hearsay because this would be treated as an interlocutory order for the purposes of the relevant section in the Evidence Act. So, you have to prove your case by admissible evidence. That's the next point. The next point made in Zane and Allen is this: in an undefended hearing, the trial judge has the discretion to have regard only to the evidence of the party before the court, and not the affidavit evidence of the excluded party. So this is dealing with somebody who's participated, but they've been told that because you won't make disclosure or because you won't comply with these directions, we're not going to hear from you anymore. The trial judge in an undefended hearing may exercise the discretion to have regard to agreements reached between the parties prior to the hearing as to such matters as the value of property, if such agreements have been noted on the court record or where there is admissible evidence establishing the agreement. The court does not proceed to conduct a hearing as an undefended matter. Where a court does not proceed to conduct a hearing as an undefended matter, it is still bound by the same general requirements as to proof as in a defended matter. Again, subject to the notion that if the respondent isn't there and it's going by default, then it's really an interlocutory order that the court's going to make. Now, let's jump to your point. If you have a respondent come to you and say, I've just been given these orders, it says my house is about to be sold and the proceeds divided 60-40. What can I do? What can you do?
Apply for it to be set aside.
Sure. Under which rule?
I don't remember the numbers very well. 13, 14, somewhere around there.
No, not even close. It's not the slip rule. I think that's what you said before. It's Rule 16.052A that says where the order is made in the absence of a party, the party can apply to have it set aside. What do you have to show to get it set aside?
it's the same
It's
as...
more about everything, isn't it? Don't you?
It's the same, it's much the same as for Rule 282 under the UCPR, that you've got a prima facie argument, and that there was some reason for you being slack.
Sort of. An explanation for the delay in appearing, why you weren't there. Doesn't have to necessarily be an adequate explanation, because it's a matter of discretion, and no one factor overrides another, and some things might attract more weight than others, but generally there needs to be evidence about why you weren't there, or why you haven't done what you were supposed to do. And then you need to show that it's more likely than not that the court, if it heard the case, would make a different order to the one that was made. That's a different test to the test across the road here. But it's a test that has been approved in the federal court and applied in the family court, in the full court of the family court. It gets a run in our jurisdiction in the Federal Circuit Court, mostly in migration cases, where applicants in migration cases don't turn up on their court date, and so we dismiss the proceeding for want of appearance, and then they apply to have that order set aside and have their proceedings reinstated. And there's lots of cases that talk about what you have to show. You have to show why you weren't there. Why didn't you turn up? And is there any substance to your explanation? And secondly, even if there is, it's not so much that you have to demonstrate a prima facie case. You have to demonstrate that if the court hears this case, is it likely that it will make a different order to the one it's made? Now, in the migration context, you've dismissed the application, so that requires an inquiry about whether the court is likely to simply dismiss it once it hears it again, or whether it's likely to set aside the decision under review and review it for a hearing. And that requires an examination of the merits, as you'd expect, and a conclusion about whether the merits have any substance to them or not. Same in the family law jurisdiction. It's been applied in the family jurisdiction where respondents haven't shown up, and then apply to have the order set aside. So that's the test. So you get your affidavit material from your respondent client, you go along, you say, this is why we didn't show up, we were out of the country, the service was all bodged up and I didn't know about it, or whatever it was. She's asked for 60-40, but here are the real facts. If these facts are accepted, it won't be anywhere near 60-40, in fact it'll be 60-40 in my favour. You need to set the orders aside and we'll have another go. Yeah? Let's assume on the first court date the other side does show up and they've done the right thing. They've filed their response, they filed their financial statement, they've got a little bit of an affidavit there that says a few things. What are you going to do then if you're for the applicant?
Negotiate.
Correct. You should have done that before you turned up on the first court date, but all right, it's a big list, 9:30, it's a big list, go outside, have a talk, I've got other things to do, I'll get back to you. And you settle it, that's great. You don't settle it, what do you want? You want directions to move the matter forward, yeah?
Yeah.
Okay. There's a standard form of directions kicking around, isn't there? But one of our past judges developed, bless his heart, that he and I disagreed with, vehemently over. I don't like them because, well, why don't I like them? Tell me. Why don't I like them? Oh, come on, it's not that hard.
Too general.
Sorry?
They're too general.
That's close, that's on the right track.
There's already the rules that you have to disclose.
You're talking about disclosure, we'll get to that later. What's the time? I want to make sure I leave enough time for that. It's because if you use a standard set of orders that people can just print out and take up to court, nobody thinks about their case. That's the sad fact. If you don't have a standard set of orders, you've got to think about what are the directions that we need here. And the directions that you actually make are a function of what needs to be sorted out in the case. And what needs to be sorted out in the case are the issues, yeah? Right. So it's called differential case management. This case will get managed differently to this one, to this one, to this one, because they need different things. In this case, the issues might be around valuation of some family trusts or some other business interests. But in this case, the issues are about whether somebody has to repay a loan to their parents or not. And you might not necessarily make the same directions in those two. In this one, you might make orders for valuation, and if it's a significant enough case, you might make orders about the conferral and hot tubbing of experts and all that sort of stuff. In this one, you might make an order for the provision of evidence from the people who say they're owed the money. File an affidavit from the parents and get them on oath, and let's see what they say, and put in all the documents. So you manage the cases differently. And if you manage the cases differently, it focuses the attention of parties on what needs to be sorted out. And if you get rid of the issues one by one, then ultimately you get to a result. So you need to think about the issues in the case. And in a property case, that's not that hard really, is it? It's a 4-step process. I know there's some cases out there that argue about whether it's 3 or 4, and you know, the eastern states have a different view to the western states and the western state. But let's go with 4, shall we? Yeah, 4? Or 5? Shall we go with 5? What do we do with Stanford? It's like hanging out there, isn't it? Stanford says, before you do anything, you've got to make sure that it's going to be just and equitable to do anything. I don't know. It was a bit easier before Stanford, but if you don't let it bother you, it's fine. You just put it in. It will sit there by itself. So, the first thing to do is to identify the assets and liabilities and financial resources, whether you include Stanford or not. That's the first thing you've got to do. And you've got to do that by reference to both the legal and equitable ownership, yeah? Who does that? Who does that? Equitable ownership? Yeah, truly? I've never seen that. People just go, oh, we own this and we're in joint names and blah, blah, blah. But that's important, equitable ownership as well. So that's the first step, and that's where the first set of issues will arise, isn't it? This is in the asset pool, this isn't in the, we're quarantining this is an inheritance, blah, blah, blah. Stanford does take care of all of that, doesn't it? It says you have to value everything. You have to identify everything. You can have your contribution arguments later about whether we've contributed to this or you've contributed to that, but everything needs to be identified and it needs to be then valued, doesn't it? That's the second ground for fertile ground for dispute, the value of things. One of the things that I see fairly regularly is I don't think it's an inability, it's just a failure to identify the nature of the assets that are being considered. Trusts, for example. People talk about trusts as if they're a legal entity. They're not. People talk about a business as if it's a legal entity. It's not. It's owned by whatever entity, legal entity, conducts it. That might be a company, it might be a sole trader, it might be a partnership. But it's necessary to identify the legal entity that is holding these assets. Who's the trustee of the trust? And what are the terms and conditions of the trust? It might be that it's a discretionary trust and it comes within, under the control of one of the parties, and it comes within that Kennan and Spry case. Who's read that? Yeah, I haven't read that either. Kennan and Spry might be in that. So you need to identify those things because you need to know what's going to be valued if there's a dispute about value. Say, for example, there's a business that's operated by a company, and the business, when it's valued on a going concern basis, net maintainable earnings basis, for example, has a value of $500,000. That's what it's, if you sold it on the open market, that's what it'd get. But it's conducted by this company that is a trustee for a discretionary trust. And the way in which it operates, the trustee of the trust sends the money, the profits and whatever, back into the trust, and the trust has got its own liabilities. It might own some land separately that it's mortgaged or whatever, and it might be some beneficiary loan accounts in the trusts where people have, taken money out of the trust, or it's been distributed over the years. But you know how accountants do these things; they create all these loan accounts. And when you do all of that, when you look at all of those and you set one off against the other, the underlying net wealth of the parties is zero. So it's important to identify all of that. And in a lot of cases, people don't. They just come along and say, the business is worth X and we want a share of X. Well, you need to look at the whole thing and take that into account. So think about, in terms of the directions, think about what it is that you're going to value. Is it the shares held by the company, by the parties in the company that controls the business that really is the underlying asset that attracts the value? Answer to that is yes, usually. It's the shares that need to be valued, not the business. If you get the shares valued, the business is going to be valued as part of that. To get the value of the shares, you've got to value the business of the company. So have a think about, apply your mind to that and be precise about what needs to be valued. And take into account in your directions any particular focus that needs to be given on to the valuation. For example, there might be a life interest in land that needs to be valued. Who's seen one of those? Sort of thing you read about in McGarry and Wade, isn't it? You never see it. They exist. I've seen a few people who have life interests in land. They're allowed to live there until they die, and that needs to be valued. And the accountants have all sorts of trouble trying to do that, but you need to ascribe some value to it to be able to deal with the case. So apply your minds to those things. Get the valuation type things sorted out. So you've got let's talk about superannuation. What do the rules say about superannuation information forms and things like that? Any idea? They should be attached to your financial statement when you file it in the first place. Who's seen that? You might be starting to wonder why we even have these rules. The rules say attach to your financial statement or your affidavit of financial circumstances a superannuation information form or the latest account in an accumulation fund. You need to get those. You would all be familiar with the specialist organisations that value superannuation interests, the special ones, the DFRDBs and the military supers and things like that. Think about whether you need that in your case. There's a couple of organisations that provide specialist valuations about those sorts of things. What about overseas superannuation interests? What's the first question you need to ask yourself about that?
Is it property or is it financial resource?
What else? Somebody else over here said that?
Can an order be made about it?
Yeah, and what determines whether an order can be made about it? Well, it's what she said. Is it property or is it a financial resource? And I'm sure you meant when you said when it's property, is it something that can be treated as if it were property? Because that's what the Act says about our superannuation. Not that it is property, but it's treated as if it was property. But overseas super is different. And if you're dealing with an overseas pension or superannuation interest, then it is more than likely, in fact pretty much guaranteed, that you won't be dealing with a superannuation interest for the purposes of the Family Law Act. You'll be dealing with a financial resource. And it needs to be taken into account. I've had some people asking me recently to wait while they get procedural fairness of some trustee in the United States. And the trustee's written back and going, you want me to do what? I don't understand any of this.
Yeah.
I don't either. So understand that an overseas interest is generally a financial resource. Sometimes it can be property, but it depends on the rules of the interest. There are overseas pensions, of course, that can sometimes be property and other times be financial interests. So be on the ball there to make sure that you get a direction, if you think you need it, about the valuation of that interest and think about who's going to value that. Not as property, but as a financial resource. What's the next step in the 4-step process? Contributions, correct. The issues there are, generally questions of weight. We provided this, we provided that, it's 60%, it's 40%. But one of the issues there that arises regularly are interfamily loans, contributions from families. Family members, and they always turn into loans. They start out as gifts and then they have to be given back. The way to deal with that is to get everybody on oath. Get them to put up or shut up. Simple. And then you can see what the documents say, if there are any documents, often there's not. And if there are documents, you've got them. You've got them up front and everybody knows what the case is. Sorry, something just slipped my mind. Going back to the trusts, in a contribution argument, it's sometimes useful to look at the distributions that are made in the trust. There's a case called, I can't remember what its anonymised name is. It's called Eggleton. Eggleton. And it went to the full court. And in that case, it was a property adjustment case, bitterly fought, and the husband was the trustee of a trust. And it was a long-standing discretionary trust. It had been established back in the 1920s. And the trust had a number of different trustees, different family members over the years. It was the vehicle that the family used to conduct a business. It was very lucrative and made a lot of money. But eventually, by the time it got to the court, it was just the husband who was the trustee. He was the sort of sole remaining member of the family. And he was in control of the trust. And for the last 5 years or so, he had been distributing the profits of the trust in the way it had always been distributed. The wife got this, the wife got these distributions, the husband got these distributions, but they were all sort of, book distributions. They would draw from the business their living expenses and things that would be accounted in the usual way through the trust. And so the husband said in the property case, he said, I have made all of the contributions because I'm responsible for the trust, I'm the trustee, I've caused the distributions to be made, and more than that, I was the guy who sat in the shop and generated all the income. The trial judge said, well, that's not quite right, because the distributions by the trustee to the beneficiaries of the trust were tantamount to gifts. The trustee makes a decision according to the terms of the trust to distribute the income of the trust in this way or that way. And having done that, the beneficiary doesn't give any consideration for it. It's just like a gift. You get a windfall. And if you view it in that way, you can then go to the cases like Kessie. Yeah, Kessie talks about parties getting gifts, and the donor of the gift, the court should infer that the donor of the gift intends to benefit the donee, not the donee and the donee's partner or anything like that. So if you apply that principle by analogy, then when a trustee gives money under the terms of a trust to a beneficiary, and then the beneficiary then uses that money for family purposes, that's a contribution by the beneficiary, not a contribution by the trustee. It's a contribution by the beneficiary. It's a gift to the beneficiary who then uses it for whatever purposes the beneficiary wants to use it for. The trial judge said, if you do that and you look at the books, she's contributed way more than you have. And the full court didn't disturb that. So you need to analyse these things. Don't take anything at face value. And have a look at the way in which the parties have decided to conduct their affairs. And you would have seen the cases where money has been distributed to children in discretionary trusts, and the children are now adults, and they've picked a side, and they want their money in their loan accounts. It's a perfectly legitimate claim, isn't it? So understand the financial dealings, and when you get the valuations, think about those things as well. Are we going to be able to use that to our advantage? Are there any other contribution issues that people see that they think are tricky?
Homemaker.
Oh, that's not tricky. Is that tricky?
Oh, just how do you quantify that?
You don't.
Yeah.
You don't even attempt to.
Yeah.
You take it into account. It's all, it's an art, not a science. You take it into account. How do you take it into? People want to run arguments, of course, that I've provided all of the homemaker contributions and I've earned all the income and I've looked after the kids and, she just went to the poker machines or he just lay on the couch and watched football all the time. You just make an assessment and you don't tell anybody how you assess it. Well, read the judgments, they don't. So, there's any others? Any other tricky contribution? Sorry?
DD.
Yeah. There's a recent full court decision about that, isn't there? Where they talk about Spagnati. Has anybody read that one? No, I haven't read it either. It's on my list to read. It's only fairly recent. So, Canon says that if one party, through their conduct, makes the contributions of the other party more difficult, you can take that into account, yeah? And then there's this case called Spagnati that says, well, that's true, but the court's got to have evidence that connects the behaviour with the contributions. You've got to have that, and it's generally expert testimony that connects the dots so that you can say this has caused the contributions to be made more arduous. The circumstances in which this person has made their contributions have been more taxing than they would otherwise have been because of the other side's conduct. And Spagnati says you've got to have evidence that connects the dots. But there's this recent one that I haven't read, but I read the quick head note that I saw when it came through that suggested that, they might have watered down Spagnati a bit. So there's some homework. I'll do it too. And there'll be a test whenever you're next in my court. So they might have watered that down a bit. But you're right. That's again another tricky one. I mean, how do you quantify that? You can't quantify it. I've only ever seen one Canon case argued and run successfully. Every other one seems to fail for want of proof, and that's because people don't apply their minds to Spagnati. Has anybody run a successful one? It's not to say they don't happen. Has anybody run a successful one? No. You don't see them, and it's because people don't apply their attention to what's required to be proved, and it's not hard. You just need some evidence from a psychologist or I suspect a GP probably even get you over the line, but you just don't see it anyway. So, Devi, anything else?
Inheritance.
Well, inheritance is they come up in two ways, don't they? Is it in or out of the pool? Answer is it's in the pool. It's always in the pool. And why is it? This notion of a pool is wrong, isn't it? Yes, the answer to yes. And Stanford says it's wrong, because Stanford says the first thing you do is look at everything. You look at everything, and when you read Stanford, they say when you go through the process and you get to the conclusion that there should be a property adjustment order, the court is not limited to adjusting the parties' interests in the property to which they contributed. The court can adjust the parties' interests in their property or any of it. So, in an inheritance situation, 2 days before the trial, your client gets $2 million by way of a big check, it goes in the bank account. It's sitting there on the day of the trial, yeah? Can the court make an order about that? Yes, of course it can. The other side might not have contributed a ZAC to it. They might not have contributed in any way, shape or form to your client getting the inheritance, but it's still property available for an order to be made. That's what they say in part of Stanford. They say that in Hickey as well and in Coghlan, that you're not limited just to the property that the court identifies the parties each having made a contribution to. It can be property that one side has contributed nothing to, and they still have to share it. And of course, that's one of the joys of my job. When you point that out to people in court and they go, no, that's not right. Yes, it is. It's the men who have the most difficulty with that. So inheritance is irrelevant in that first way. The second way is contribution. How do you deal with it? And Well, that's just an assessment process. Did it come at the beginning of the relationship? Was it a bequest from Aunt Mary because you both looked after her? Was it at the end of the relationship? Did it come with a note saying, under no circumstances is he to get any of this, or is she to get any of that? You know, you just need to assess the circumstances. And Kessie helps out with that in the cases like Kessie. What's the Farmer and Bradley, I think, is an inheritance case as well. There's a whole bunch of cases, some of which say on the, is it in the pool or out of the pool? Some say it's out of the pool, some say it's in the pool. But when you analyse those, they're all pre-Stanford, of course, but when you analyse those, you'll see really what the court's saying is, we've looked at the contributions, and one party has made no contribution to it. So let's quarantine it over here. Let's make it, in terms of Hickey and Coghlan, let's put it in its own little pool. Yeah? Because in Hickey they talk about having the preferred two-pool approach, superannuation, non-superannuation. And that can get expanded out into superannuation, non-superannuation, inheritances, this, and this. You know? So inheritances are relevant in those two ways, but they're not, people think they're tricky, they're not that tricky. They're not that tricky. Anything else?
Personal injuries claim.
Same thing. What's the case there? Alakovsky is the case. You've got to look at the award and see how it was made up. Often, in this day and age of personal injuries litigation, it's not. It's just a lump sum. You can't tell how it's made up. So you just have to do your best. Just have to do your best. Yep.
Family pets, where would you consider them to come out?
Family pets. I like to tell this story. I got Judge Bowman one day, back when he was a federal magistrate, I got him to make a contact order for some dogs. And I don't let him forget that. My client was the president of the Weimaraner Society or something, and they had 2 dogs. And the parties were very attached to their dogs, as you'd imagine, and I wanted an order that my client could swing by every second weekend and say hi. That's what we got. They're chattels. Animals are chattels.
Joe Harmon's written a quite quirky decision about that. For those of you who saw me a couple of years back, I actually did a review of that case. I can't remember it off the top of my head, but I'll bring it along to my case review tomorrow.
It's interesting.
Yeah,
it's
it
good
sort of
fun.
slides through the emancipation of slaves and, you know, those sorts of things, and decides it's a challenge, basically.
Yeah, animals are chattels. They have a value. Probably, usually not as much as people think they are. And you divide them up. Righto. Any other tricky things? No. Right. So what's the third stage? 79 4D, E, F, and G. So 79 4D talks about, what does it talk about? I can't remember. Child support's in there. I think that's 79 4E. And then the 75 2 factors are the ones that attract the most attention. Any tricky particular issues that you want to talk about there? No? There's, in my experience, not much arises under 75 2. It's all pretty straightforward. One side earns lots of money, the other side doesn't. One side's got the kids, the other side doesn't. One side might have access to some family trusts that really are controlled by other members of the family. They've been getting distributions for the whole of the marriage, and all of a sudden when they separate it stops. You know, you take that into account, you go, oh, I made an assessment, I think it'll probably continue, so you adjust, make an adjustment. It's at that point, the third stage of the process, where foreign superannuation interests generally get a bit of a look in because they're financial resources as opposed to property. Beyond that, not much generally arises in practice, but if there's anything anybody wants to ask about, now's your chance.
What about an inheritance that the person has passed but has not yet been defined or allocated?
Or a person's not passed, but they're just really, really sick. Or worse, they're really, really old.
Yeah.
And everybody's expecting them to pass. They do, they stand up and go, oh, she's 65. That's no good. There's a line of authority about that. White and white is the case, I think, and it's about making some sort of. You have to be satisfied they're going to die soon, and if you're satisfied they're going to die soon, you can take it into account as a financial resource, a future financial resource. But all of the cases I've seen tend to get a bit anxious about trying to go too far down that path of valuing what people are likely to get. It's a prospective, nebulous sort of, vibe of the thing again.
Could you support an adjournment?
Yes, you could. You could. I've seen that done. They're just about to die. If we wait long enough, it'll be. and of course, the other side say, no, it's urgent. We need to do it now because they're just about to die. So you could adjourn a case. Yes, absolutely. 79.5 provides for that to happen, doesn't it? If there's going to be a significant change to the asset pool in the next little while, the court can make an order for an adjournment and at the same time make a partial property settlement if it wants to do so. So that would be a perfectly legitimate attempt to adjourn a trial if somebody's unwell and there's likely to be a significant change to the asset pool. But prospective is, it's hard to deal with a prospective inheritance, which is why most people give it away. They'll raise it at the directions hearings, we want to see the will and we want to see this, and then by the time you get to trial, they've all forgotten about it because it's too hard. Anything else? Righto. And then we get to the form of the order. The fourth step, figure out, once you've gone through the process and you've decided who's going to get what, and the full court says you should try and do it in percentage terms, doesn't it? Think about it in percentage terms and then carve up the property having regard to the items that are available, and that's where you then have to make a decision about who gets the family home. Have a look at a case called Phillips about that. Phillips and Phillips, very good counsel in that case, just want to say. He didn't win the appeal, but that was there was an adjustment. The husband in that case felt hard done by because he didn't get an extra $5,000, and so actually I think we won. I can't remember. The husband wanted an extra $5,000. I was for the wife. The trial judge gave us the house, and by giving us the house, it means that we got more than we were entitled to. According to the trial judge's assessment, we should have got about $5,000 or $10,000 less than we actually got. The trial judge said, but she's got to have the house because she's got the kids and it's the best thing to do. And so the husband felt aggrieved by that, and we went off on appeal, and the full court said, it's only $5,000. It's a just and equitable order. It's not a mathematical order. It's a just and equitable order. And when you take into account the things the trial judge took into account, even if he didn't get what it was that the trial judge concluded he ought to get, it's still not, it's still a just and equitable order. So bear that in mind. And that goes as well for superannuation splitting orders. That's where you decide how much you're going to give somebody for a superannuation order and how much you're not. Right. So then you get to, I've got my order. We've worked it out, we've agreed, we've got a consent order, or the judge has made an order. We made some poor judge's life a misery, made him decide the case. Here it is. And the other side doesn't do what they want, they're supposed to do. What do you do then? Enforcement, contravention, what else?
The question is whether you can bring it back under 79A. I think.
There are all these options. Which one would you go for? Well, it depends on what you want to achieve, doesn't it? Yeah. Depends on what you want to achieve and what you're trying to enforce. An order for the payment of money. He has to pay or she has to pay $100,000, and there's no default clause. There's no, and if you don't, the house gets sold. It's just pay this money. How are you going to enforce that? An enforcement application. Enforcement's dealt with in the rules, Part 25B. Who's read that? Read that, because nobody's read it. Nobody has read it. I get these applications all the time. It drives me to distraction. An application in a case, we want an order that the person who's supposed to pay the money pays the money. We really want them to pay the money. We're not joking now. We really want them to pay the money. And we want you to order them again to pay the money. Okay, I'll order them again. But that's what happens. You get these applications in a case saying an order that he or she pay $20,000 in accordance with the orders of Judge X made on this date. Why would you want to get they've already got one order, they've not complied. Do you think another order is going to help? No. So, the trick is to go to Part 25B of the rules, and you'll see when you look at it that it deals with enforcement of financial orders and obligations. 25B, point 2, in fact, deals with money orders. And it defines what an enforceable obligation is. I won't bore you with that, you can read that. But it covers child support debts and orders for property adjustment require the payment of money. It also applies to orders for the possession of real property and a few other things. And the process in 25B doesn't seem to be fully understood by anybody, I don't think. Because if people understood it, then they wouldn't make applications asking the court to just make another order in the same terms as the one that they want to enforce. This also applies to the enforcement of agreements as well, by the way, some sort of financial agreement. What you do to enforce an obligation to pay money is to look at the rules, and you'll see that it can be enforced by one of 4 different sorts of orders. An order for the seizure or sale of property, real or personal property, an order for the attachment of earnings or debt, an order for sequestration of property, or an order appointing a receiver. That's how you enforce a money order. You go and take their property and sell it. It's the old writ of FIFA. Or you attach their earnings, the garnishee order, the old garnishee process. Or you sequestrate their property. Who knows what that is? No, it's not quite it's sort of like bankruptcy, but it's not. They're not bankrupt in the Bankruptcy Act, but you seize their assets and you sell as much of it as you need to get what you're entitled to get. Or an order appointing a receiver to some property. I did that recently. Appointing a receiver is handy because it scares everybody. They don't know what a receiver is, except that it's going to cost a lot of money. To get one of those orders, you file an affidavit, Rule 25B.12. If these rules require a person seeking an enforcement order to file an affidavit, then the affidavit has to set out certain things. Rule 25B.12. None of it is onerous. Here's the order, this is what they're supposed to do, this is what they haven't done, we'd like them to do it. Pretty much. Have a look at the rules, it's all there. And then you apply to the registrar. Apply for you can, before you apply for an enforcement order, so one of those types of orders I've talked about, you can apply to the registrar, ex parte. Sorry, let me go back a step. The rules provide this, 25B.16. Before applying for an enforcement order, a payee A may give a payer a written notice requiring the payer to complete and serve a financial statement in accordance with the approved form within 14 days after receiving the notice. So you can just send to the other side a notice saying, tell us what your financial position is. And that the rule requires them to do that. Remember that, and we'll come back to this shortly. Second thing that you can do, it's an alternative, is file an application in a case and an affidavit and apply for an order without notice to the respondent. So ex parte, yeah? Requiring the payer to complete and file a financial statement in accordance with the approved form, or requiring the payer to disclose information or produce to the payer copies of documents relevant to their financial affairs. So you can ask nicely, or you can get the court to tell them to do it. Your choice. There's no obligation to do one before the other. It's whatever you think will work. And the registrar has power to hear and determine that application and issue the relevant order. You don't have to come to a judge. you can get a registrar to do it. I haven't heard of any registrars doing it because they're never asked to do it. It's like the old oral examination. You'd go down to the Maggie's Court, you'd file your application, the registrar would go look at it and go tick, here's your summons, you'd serve it, and then they'd turn up and you'd question them. Did you bring your tax returns? No, why? All that stuff. Right. So you can do that. Once you've got the information, or if you don't think you need to get that information, you can ask for an enforcement hearing. 25B.17. A payee may, by filing an application in a case and an affidavit that complies with the rules, require the payer, or if the payer is a corporation, an officer of the corporation, to attend an enforcement hearing. The payee may require the payer to produce documents at the enforcement hearing that are in the payer's possession or control relevant to the enforcement application by serving with the application a list of the documents required and a written notice requiring the documents to be produced. So you can tell them what you want and they have to produce it. We'll get to the bit that makes them produce it later. And then the payee has to serve on you the documents that you've asked for 14 days before the hearing. Lots of luck with that. But that's Rule 25B.173. And then 25B.18 provides for the obligations on a payer. They have to do the things that they're supposed to do. They're supposed to turn up at the enforcement hearing and answer questions and produce the documents that are required. 25B.20 is a pretty handy rule. It says that a person commits an offence. So it's not a civil penalty. It's not anything else. It's an offence, criminal offence. If the person does not comply with the notice under paragraph 25B.16, comply with an order that the person complete and file a financial statement, or produce the documents they've been asked to produce, if they're served with an application for an enforcement hearing, if they fail to comply with the rules, or if they fail to show up. It's an offence and you're liable to a criminal penalty, a fine. Nobody knows about that. Can't wait to be asked to impose the first fine. And it's an offence. 25B.20 says it's an offence of strict liability. So there's no defence to it. So none of this namby-pamby, here's your application, please order them to pay the money again. Here's an enforcement summons, turn up or you suffer the consequences. It's in the rules. And then the next subdivision, 25B.2.3, talks about the different enforcement warrants that can be ordered. The ones that you'll be wanting to get ordered or get issued are either the warrants for the seizure and sale of property, real or personal property, or the garnishee type orders. Sequestration is unheard of. I haven't heard of anybody ever doing that. And receivers are not common, pretty uncommon, but expensive. So people avoid that as well. But it's handy if you've got a business. If the only asset or the significant asset is business, we'll appoint a receiver to the business. The receiver can receive the profits, receive the income of the business, pay off the expenses as they need to, and we can get the profit until you've paid off what you owe us. So that's the enforcement side of things. That's it in a rough thumbnail sketch. Read the section, read it. There's a whole lot of gems in there. And somebody mentioned before about if a respondent doesn't turn up at the first court date, what do? You issue a warrant of arrest. No, you don't. But here, in the enforcement regime, if they don't show up, absolutely there's an express power to issue a warrant for their arrest. Same as in a contravention proceeding. But it will repay reading because I have not yet seen an enforcement application that even comes close to those rules. People don't even refer to them. They don't even know they exist. So, anyway, before when I asked about enforcing orders, somebody said contravention application. Would you bring a contravention application?
Part 13A.
Sorry?
Part 13A.
Yeah, would you bring one? Part 13A?
Sorry.
You're not going to get paid though.
You could get
Through
somebody's bottom kicked, but that's about it.
112 AD is the section, isn't it? I think deals with contraventions of orders that do not deal with parenting. If it's a parenting order, then it's dealt with under Division 13A. Division 13A. But contravention of property orders is 112 AD of the Act. And when you look at 112 AD and the relief that the court can give if it finds that a contravention is proved, there's the usual suspects: do nothing, fine, imprisonment, bond, I think, bond. And then there's the last one. Who knows what the last one is? Sorry? No, not jail. Make any order that the court thinks to enforce the order, or words to that effect. So people come along in contraventions in property cases and say, we want you to fine this person or whatever, but they never ask for the order to be enforced. But there's an express provision, and make any other order that the court thinks fit to enforce the order. So if it's a particularly heinous breach, you might think about bringing a contravention application if you want to cause some additional harm. That's what that's about, really. It's punishment, sanctions for not complying with the court's order. And tomorrow in my court, if you want to come and see something, one of my best friends, who's languishing out in Her Majesty's jail out at Gatton somewhere, is coming in for a day out. He went into jail for breaching a property order. I gave him 12 months. He's still there. But that was for breaching a property order, and that contravention order in that application in that case was appropriate because there's nothing left. There's nothing left. And so he made off with all the dough and said, I can't comply with the orders, there's nothing left. And the wife brought the contravention application. And no, sorry, wrong, not a contravention, that was a contempt application because there was nothing left. On a contempt application, the powers of the court are more circumscribed. We can't make orders to remedy the contravention. That's why you need the 112 AD application, not the 112 AP application. Now, there was a third alternative over here, 79A. 79A can be engaged where somebody's in breach of an order, can't they? Can't it? Answer yes, yes, yes. These aren't trick questions, by the way. When would you bring a 79A application as opposed to an enforcement application or a contravention? Yeah. When you want to change the substance of the orders, where something's happened, the order's been breached. For example, the contempt man, if he had some money in the bank, it might be appropriate to bring a 79A application as well, saying the orders have been breached, he hasn't done what he's supposed to do, and the situation or the circumstances have now changed because of the breach, such that the orders are no longer just and equitable. We want you to set them aside and do it again. Do that. But so they're really the three contenders for enforcement: the enforcement application proper, the contravention application, and then the 79A. It's 4 o'clock. It's time for me to finish. Sorry I didn't get to disclosure. Are there any questions that you want to ask?
Which method do you think would be best out of the three in terms, well, out of the two really, enforcement or contravention? It sounds like contravention might
Well,
be
it
better.
depends. It just depends on what you want to achieve.
Yeah.
If you want to, I would have thought that in most cases the enforcement is much better because you can do a lot of the work that you need to do ex parte. You can get the orders you want ex parte, you don't have to. There's a lot more coercive power there in the rules to get people to provide their financial information. You can just give them a notice and they've got to comply. On a contravention, you're going to have all sorts of arguments about the form of the contravention application. You know, all those tricky little points about whether it's duplicitous or whether it, properly pleads a contravention, all that stuff. You can avoid all of that. The only thing you don't get to do is to get the person fined or put on a bond or imprisoned. But in a property case, I don't know that happens all that often. If they've done something especially bad, then it's usually a contempt application. So I would, become really good friends with the enforcement sections and use them, because if you know them, you'll be, a big fish in a small pond, and you'll be able to use them to your advantage. You really will. Nothing else? Great.
So, thank you, Rhonda, for taking us through that.